preamble. Could everyone stand, please? And if you'd like to repeat after me, you can. If you don't, just take it all in as you said. So this is the honor preamble. This is how we start each and every class should start. All right, we the people. We the people of the Aboriginal Republic of North America. Natural Aboriginal rights. Is the oldest recorded. Aboriginal indigenous peoples of the Americas.
Good morning once again. Definitely appreciate everybody for being out. My name is Troy Smokes. I reside presently as the chief within Shechem Exum. For those of you that are new, bottom line, if you study the history of our people throughout the earth, we always had villages and we had chiefs and we had various rulers, kings, queens, things of that nature that assisted us in navigating forward and gaining perspective and introspection on how to move forward as a people and how to gain, as it says, autonomy. And autonomy is just simply that we work together as a people to galvanize our resources, to help one another to grow in an efficient manner by way of natural law. Everyone that's here today, you notice we gave you the paper right here that says economics. Economics, all it means is household management. But when we think about the word economics, we always think about our government creating an economy for us. But it's not about a government, it's really about what you do personally to create an economy for yourself. Okay? So what you're going to find is that we work to help you gain an understanding of how to create a better personal economy for yourself, for your family, for your community, for your state, for your nation state, and it continually goes from there, if that makes sense. At present time, if you really pay attention from an economic perspective, we don't have economic, social, or political power. Not as a people. Individually, some of us have arrived from a financial perspective, and that's a beautiful thing. However, overall, we have not yet achieved the levels of success. When I say success is relative to you as an individual and what your desires are. But from a financial perspective, if I were to say, have you achieved your grandest desires? And when I say grandest desires, let's think about this. How many of you have been able to secure a financial reserve for your children's children's children? Because there is a saying that says that a wise man builds an inheritance for his children's children. So look at Steve Forbes. When he came out of the womb, he was already a billionaire, right? How did that occur? We know that on the backs of our people that they've been able to achieve certain financial success based upon just navigating through certain economic resource. So what we're going to first do is I'm going to turn it over to an individual I have a great deal of respect for, one of our leaders within the jurisdiction of Shechem Exum that is helping people resolve economic encumbrances. Have any of you ever been so broke you feel like you couldn't breathe? I know I've been there before, right? Yeah. Have any of you ever went to the Mac machine, you go to put your card in and laugh back at you? You know, it's crazy. You got to put $1 in to take out 10. You know what I'm saying? I don't know if you've ever been there, but let's be real. Some of us have been there before, and there's nothing wrong with that. The question is, how do you not ever be there again? And so what we're going to do is take you through some information that's going to help you gain resolve in a lot of economic areas where you're challenged. So what I'm going to ask everybody to do is take a pen and some paper, because what's going to happen is there are going to be questions that you're going to have. One, I want you to write down your questions. Outside of the questions, what I also am going to ask you to do is take notes on what's shared. Does everyone have paper?
No.
Okay. Chief Jawad, if you can make sure everybody has a piece of paper and a pen, please. Because on the real, how many of you have been to school before? And you didn't take a good note, and you had to then call a friend and say, oh, can you tell me? But see, people take notes based upon their perception and where they are. And so sometimes they'll try to share with you information, and if it's based upon their perception, it may not be at a level you understand it, because comprehension is relative. So we ask everyone to take notes, because I want you to be able to walk away from here saying, I got the goods. Does that make sense? This gentleman is well studied in his area. He is one of our Aboriginal jurists. He has studied for some years now and really just took the bull by the horns to help people to move forward and navigate through financial encumbrances. And now they're winning. Literally have won multiple cases against some major companies. And so, I mean, he is the best of the best. You couldn't ask for anyone better. So I'm going to turn it over to one of our law masters, Khalif Antani. Everybody, come on, give it up for him,
Please. How's everybody doing?
Great.
All right, so my objective today really is just to give everybody a focus on dealing with debt. I'm sure everybody has had some type of debt in their life, correct? Whether it's a mortgage, student loan, credit card, some type of debt, right?
Yeah.
Okay. So what I've come to realize is that a lot of the information that is shared throughout the community is general, vague, and ambiguous. Okay? So what that means specifically is that in the event that you try to get some type of relief for the encumbrances that are being pressed upon you, you have general information and you don't know how to take it and actually get a remedy from it. So what I specifically discuss, as Troy stated, are the consumer protection laws. In my opinion, it should be a prerequisite in school for everybody to know how to protect it from contracts and debt obligations, just because it's something that you got to deal with every life. You're signing a contract all the time, and a lot of the times, you know, there's a lot of jargon within the contract that we don't know what we're signing. And in the event that you fall on hard times and you're trying to work out an agreement with your alleged creditor, he's either not compliant to work with you, or they start, you know, trying to seize property and do things of that nature to really, you know, stress you out. I've been through it personally myself, and with the assistance of the nation giving me some preliminary information and teaming up with some other people within the nation, we've been able to address a lot of issues, to help people, you know, break free of the chains that's, you know, holding us down. Because ultimately, I mean, the less you have to worry about is financially and being encumbered financially, the more you actually get to do to figure out what it is that you want to do in life, you know? A lot of times, you know, we're working, trying to pay off debt. You know, we live in a society where the biggest gross domestic product is debt. You know, in order to live the American dream, you gotta get into debt to get the things that you like, which really doesn't make sense. And it's okay, but we gotta make sure on our end, you know, especially as a nation, that if we do engage in a transaction, that the party that is collecting is honorable and they're holding up their end, you know, to the law. And the only way to do that really is to hold them accountable. A lot of times we do get documentation that we send out, but it's administrative. A couple years ago, that stuff used to work. You know, you send like a validation dispute letter something or a threatening letter. What it's come to now is that they're calling people's bluffs. So they're saying, you know, you don't really know anything. You just got a document from someone else. You're sending it to me, and you think that's gonna stop me from moving forward. It's not the case. So it's come to the point now where, I mean, I hate to say it, but we got to be competent to be able to function in court. That's just what it is. You know, a lot of people are scared of the courts. They don't want to go in for whatever reason. We need to lose that mindset. Everybody needs to be able to go in court and be able to present themselves. And you need to be able to speak to the subject matter of that particular encumbrances that they're trying to enforce against you. That's just what it is. There's no way around it no more. You know, they're taking our houses. You know, they're garnishing our wages. You know, you can't evade from it no more. So you just got to deal with it. Specifically today, what I'm going to talk about, obviously, how many people have a mortgage in here? How many people have a credit card? Student loan? Yeah, I was going to do a presentation. So as you can see, the main slide, mortgage foreclosure remedy and debt. I don't do anything purely administratively. It doesn't make sense. Anything that you do administratively is to set you up to go into court. That's it. The law is only as strong as you can enforce it. So you can send a whole bunch of idle threats, but it don't mean nothing until you take action. So that's what I want to give people the perception and the idea of, and make it relative to going into court. With any type of debt, it really doesn't matter. So my goal today is I want to give people specific information. I want you to be able to receive a correspondence for someone that potentially you owe or might not owe. I want you to be able to identify that individual who is trying to collect from you and what rights you have afforded to you dealing with that person specifically. So now you can go back to your own individual situations and you can look and say, hey, listen, I got this, I got this. This is what I'm looking for. This is what I need to find out. This is what you need to be doing. And if you don't do this, this is what you're subject to. So I'm trying to put the power back in the people's hands, essentially. And this is something anybody can do. It's not rocket science. Before I get into my presentation, I want to say that the laws that I'm going to discuss are not meant for you to hire attorneys. It's not. These laws are meant for individuals, consumers, natural people such as yourselves, to be able to identify and communicate with these people that are trying to encumber you, and to specifically point out, hey, listen, you did this. You're not supposed to do this. If you can't. And if they continue to do that, then you hold them accountable. So that's what I want people to take today. You know, I want you to be able to go home and say, wait, I received a Dun & Notice, which is just an attempt to collect, and they said this, or they didn't say this, or it said this, or they didn't include this when I disputed it. Because you didn't do that, now I know I can do this against you. And what you can do is, as I'll share some of my personal stories as well too, you can leverage it. So my goal is not to tell you that you can evade your personal responsibilities. No. If you enter a contract, you have to remain honorable within that contract. That's just what it is. But there's certain laws that govern how you behave within that contract. So this is strictly about conduct and behavior. If someone is carrying out a function that they're not legally authorized to do, or they're misleading you as a least sophisticated consumer in any way, with any ambiguous language to try to confuse you, or any threat to try to make you feel like you're obligated to pay without properly identifying themselves, you got recourse. So that's what I'm here to do. Starting with my first slide, who has authority to bring an action against you? This is relative to court. So if you have any debt, it doesn't matter, and someone is saying, all right, cool, you owe me, and if you don't pay, I'm going to enforce this against you. They have certain requirements that they have to fulfill from a court aspect. So in court, you got personal jurisdiction. Personal jurisdiction just means over the particular party. And a civil action, that's invoked by the plaintiff suing, which he has to acquiesce jurisdiction, just means he has to give it up. So if you want to get relief in a particular venue, you gotta allow the court to have jurisdiction over the matter. If you don't, you can't get remedy. And then it's usually the consumer. The consumer is the one that is being encumbered. In order to acquire jurisdiction over the consumer, you have to be served properly. So I know there's a lot of things that you guys hear about, oh, sewer service, or they didn't serve me correctly, or I didn't receive service. That is a prerequisite. So in order for them to force a debt properly, and then depending on the venue that you're in, Depends on how that has to happen. I'm gonna deal with PA. Everybody's from PA mostly. Yeah, for the most part. Okay. So I'm gonna deal with PA. PA is 3 different courts. They're all administrative. You got small claims, court of common pleas, and you got the federal court. And it's one court of common pleas and state court. They can serve you by certified mail. Certified mail return receipt just means that someone over the age of 18 has to sign for, U.S. Postal Mail. And once you sign for that service of original process, they acquire jurisdiction over you. So essentially what that means is if you get served a complaint, you got to address it, you got to answer the complaint. But the party that's bringing the action has to suffer an injury. Injury means that you had to injure them. So what happens in today's society is that you have people that are either hired by someone that you owe without disclosing it to you, or someone that merely just purchased the obligation that you don't know because it happened behind the scenes. And they're trying to, come after you. But before the court can say, give you them the green light to be able to go after you, there's certain things that they have to plead to the court, or else they can't pass go. And a lot of times, what we do as a people is we're good people. Oh yeah, that's my dad. Oh yeah, I signed the contract. Oh yeah, I remember I did that. No. In commercial law, you never want to admit to everything. And it's not misleading at all. That's just, practicing your legal rights. So if anybody sends you anything in the mail and they're making any allegations saying that you owe anything, the first thing you don't recall anything. You specifically deny everything. If you acquiesce at all and give them ability to start discussing subject matter jurisdiction, you're going to get buried. So the first thing is you got to identify who is trying to collect from you. Going on the first slide, as I point here, the plaintiff must typically allege in its complaint that it's the current owner of the mortgage or note being enforced. I put mortgage in there, but that could go to any debt. So, like with a student loan, you have a promissory note. Credit card agreement is not a promissory note, it's a contract. But still, they got to allege that they are the owner. And if they're not the owner, they got to say that they're collecting on behalf of the owner, and they got to disclose the name of the owner. But prerequisite to court, you should know all this before you even go in. And I'm going to go into that as well, too. The court must make findings to this effect before allowing a creditor or debt collector to proceed before allowing an action to proceed. So, you hear subject matter jurisdiction all the time. This goes towards standing. That's probably the number one argument raised by anybody. So before they can move forward to try to, summary judgment, engage in discovery, whatever it is, they have to identify themselves to the court. I wish I had a complaint here just to show you what people typically they don't do this. A lot of times what happens is the information that they give to the court is limited, vague, and ambiguous. You don't know who's the owner. You don't know who's trying to collect. They say there is a default. They don't even allege that you're in default. And the reason why that's important is because there's a lot of stuff that goes behind the scenes. So sometimes you may think that you owe a debt, but that debt is getting paid by somebody else or has already been paid by somebody else. But they're still going after you for the debt. That's a problem. If it's already been paid, especially in a situation of a mortgage, it says it in your mortgage agreement. They got to give you a satisfaction. They got to report that satisfaction on the county. And the only thing that you would have to do is pay for it. So that means you could be potentially paying something that's already been paid. Customers may challenge debt enforcement actions on a number of grounds related to the authority of the named plaintiff to the action. And I'm going to go over that in my next slide. And these challenges go to the court subject matter jurisdiction. So that. All right, this is huge. Standing. This is the argument that I think everybody uses, and you should. And the Supreme Court defined exactly what's required for someone to bring an action against you. To qualify for standing, a claimant/plaintiff must present an injury that's concrete, particularized, and actual or imminent, fairly traceable to the defendant's challenged behavior, and likely to be redressed by a favorable ruling. This is Supreme Court. So, essentially, what that means is, a couple people said they had a mortgage in here, right? A lot of times with a mortgage, has anybody ever received an assignment of mortgage or seen an assignment of a mortgage? Okay. So on an assignment of mortgage, typically it's done by MERS. People familiar with MERS? Mortgage Electronic Registration System. Long story short, that's a database company. But the reason why this is important is because they usually rely on that assignment. So the debt collector, they get an assignment or a transfer of receivables, they rely upon that. And why that's important is because contingent upon how much they paid for that is the amount of injury they suffered, if they even suffered it at all. But a lot of times what happens is they get it on a contingency basis or consignment. Consignment just means that I'm the creditor, okay, Brother Jawad hasn't been paying his bill. He defaulted on his credit card debt. And I don't really got that much time to go after him. You know, I'm indemnified anyway. I got insurance. I'm going to charge it off the profit or loss. I'm going to go ahead and give it to you guys. Depending on what you can collect from Jawad, depends on how much percentage I give you on the amount that you can collect. Make sense? So, but what that does, now does that party, that party coming after Jawad have standing to come after Jawad?
No.
Why not? He doesn't have a contract. Exactly. There's no injury. But they go to the court, and as the plaintiff, and they say they've been injured. Now, that as a consumer, that puts you in a real good position. Why? One, they can't bring that action. Two, that's a misrepresentation, right? On I don't know how many levels. You know, they deliberately lying to the court. You know, so I stay away from that, brother. But you're right in a sense. I stay away from that, and I'm gonna explain why I stay away from that.
Inclusions of the law.
Correct. The law standing mandates that the plaintiff has suffered a concrete injury in fact caused by the defendant and in some way by the defendant, and injury must be subject to remedy of the court. So the other issue is subject to remedy of the court. What happens is they try to say valuable consideration. Does anybody know what valuable consideration is? We pay valuable consideration. Anybody have a clue what that is? I don't. But valuable consideration is, it could be non-monetary. It could be non-monetary. So essentially what can happen is, he can tell Brother Jawad, here, listen, I got 8 sheep, 5 bags of chicken, and some peas. And I'm going to give you that to go collect this money. Does the court have jurisdiction over that? The court has equitable jurisdiction, okay? Money. So if someone is not paid money, they can't come in and get relief to try to collect money. But what happens is we don't know. You know, we don't know. So the minute that you're reading a complaint or someone is trying to collect from you, that automatically should get you thinking. This right here, a concrete, particularized, actual, or imminent, fairly traceable to the defendant's behavior. So the first thing you're asking somebody, all right, wait, who are you, first of all? I didn't execute a contract with you. All right, cool. And what injury did you suffer? Well, we've been assigned. Well, I don't know what that means. We've been assigned. So assigned transfer. What does that mean? And that's the other thing, as a consumer, they got to talk to you like you're a 4th grader, okay? So they can't use any legal jargon. If they use any legal jargon that's confusing, misleading, deceptive, unfair, you can take them right into court and say, hey, listen, I disputed this. They sent me some documentation. They're talking about assignment, mortgage, transfer, duly, and I don't know what none of that stuff means. I asked them to validate the debt, to give me the amount and the name of the current creditor. And they're talking about mortgagee, and I don't know what that means. That's a violation. Right then and there, you can pretty much stop any encumbrance. I don't care if it's a student loan, if it's a mortgage, whatever the case may be. If you communicate with somebody under consumer protection and they give you any information that is not within the auspices of that particular law, you got a cause of action against them. 8 times out of 10, they're going to stop what they're doing the minute that you bring action against them. I don't care what it is. I've seen it. $300,000 mortgage. Do you have a question?
Yes.
Yes, ma'am.
Retroactively speaking, not on mortgages, but other instances, can you go back after you paid and done whatever and give your money back?
You can't get your money back. But if you can prove fraud,
Okay.
if you can prove fraud, but with fraud, it has to be pleaded with particularities. What I mean by that is that you got to be able to state enough facts within that cause of action in order for the court to be able to recognize or plausibly believe that that person committed that. You got to prove intent. So that's the thing about fraud. So it's hard to prove someone's intent. So you got to get a fact to prove that that was their intent. And a lot of the information and documentation that can substantiate that is not available to you. What I mean by that is you're going to have to get bank records. You know what I mean? Things of that nature. And things, registered with the FTC, which you can get. But once you get them, on a court level, you got to be able to authenticate that information. Just prove that it's based on truthful fact. Just because me and you pulling something up online and then try to submit it into court evidence, it's going to be hearsay. Hearsay is not allowed. So you won't be able to prove that information. Go ahead.
Anthony and I went to the federal court because our original mortgage company didn't have the wet copy
Okay.
of our mortgage.
Okay.
So we made it all the way to the federal court.
Okay.
And the original person that gave us our mortgage, the bank went out of business. And they transferred it like 5 times. So when Wachovia came at 5 p.m. in the afternoon at the federal building, I come on saying he doesn't have the wet copy to the judge. And the judge says to me, and the man that was representing Wachovia said, no, I don't have the wet copy, I have a Xerox copy.
Correct.
And that was supposed to end it, but the judge told me I had to have a legal my husband and I had to have a legal representation. Well, that's what happened when I got to the federal court to try to get it dismissed, so I wouldn't have a remaining mortgage.
There's a couple issues with that. Yes, they do have to have the original. The only time they really have to have the original is you have to draw into question something wrong with that particular document legally. So
Well, they kept on they don't have my original paperwork.
I'm not arguing with you, sister.
Mhm.
What I'm saying is that you have to legally state on paper, with evidence, specifically questioning the authenticity of that document and showing that it's some way, not reliable.
But we did that, and that's how
How
we
did
got
you
the
do
federal. My husband submitted paperwork at 9th and
How did he submit the paperwork?
following Brother Ali's instructions.
Okay.
Do me a favor. Let's do this.
Just take that. It's good. Go
Yeah,
to it.
what we're gonna do, if it's okay, because some of the stuff that you have questions on, he's gonna answer amidst the presentation. So we can hold the questions till the end of the presentation, because we wanna make sure that we get all the presentation done, and thereafter we're gonna ask questions. So not to minimize anything that you just said, it's just that some of that's gonna be covered in the presentation, and then he can speak directly to your circumstance once that's finished. Is that okay? Good stuff. Appreciate you guys.
Okay, all right. So going back, so I just went over standing constitute. Did anybody need to write that stuff down? I already had it. Okay, cool. So you got standing. Now you have real party of interest. There's a difference between standing and real party of interest. Standing is a matter of jurisdiction. Okay, the party, without itemizing in a complaint or describing the particular things that I put in the previous slide, they can't bring an action, and therefore the court can't grant relief. Real party of interest is a little bit different. It's meaning that the party that's bringing the action against you doesn't have the capacity to do so. So that can be challenged, but that doesn't have nothing to do with this court subject matter jurisdiction. So Rule 17A of the Federal Rules of Civil Procedure, this is federal. Each state has some law that's comparable to this as well too. Like I said, I didn't know if we were gonna have everybody here from PA or not, so I just kept it with the federal. But an action must be prosecuted in the name of the real party of interest. You can look it up. Federal Rules of Civil Procedure 17A. Specifically in a foreclosure. I'm sorry?
Did you repeat that?
Yeah. An action must be prosecuted in the name of the real party of interest. That's Federal Rules of Civil Procedure 17A. So challenging a plaintiff's status as a real party of interest does not raise a question of addressing the subject matter jurisdiction, rather it addresses the plaintiff's capacity to bring the action. So the person bringing the action has to be the real party of interest. Like I said, not to be confused with standing, there's two different things. Standing is, subject matter jurisdiction that the court can grant relief to the plaintiff. Real party interest is the capacity of the person that's bringing the action.
You said the person bringing the action.
Yeah, so for example, a lot of times in a mortgage situation, Fannie Mae owns the government-sponsored entity. Fannie Mae, Freddie Mac owns the obligation, but they might have contracted with Wells Fargo or whoever, another entity. That entity is not the real party of interest, but they could be authorized by Fannie Mae to do so. But they would have to submit to the court some documentation for them to function in that capacity. So if they don't include, if they're saying they're the real party of interest, but they don't include some information showing that the party that is the owner of the obligation has given the authority to do so, then that's questioning the capacity of the person bringing the action. Even though the court could have subject matter jurisdiction based off of that party allowing them to do so, but they have to disclose that to you. So that's the issue. It's kind of confusing, but you know.
So for further clarity, real party interest is the same as the holder in due course?
No.
No.
No. No. I don't know. Next, note. 9 times out of 10 we're dealing with notes. Sometimes we're not. Most times we are. A promissory note is governed by Article 3 of the Uniform Commercial Code. I'm sure everybody's familiar with the UCC, right? For the most part. Yes or no? No.
We're familiar with it.
All right. So, Uniform Commercial Code defines a negotiable instrument, determines how it is transferred, and limits who may enforce it. Okay. Negotiable instruments are payable in 2 forms. They can be payable to the order or payable to the bearer. So there's a misconception with endorsements and the significance of them and how they're used. It's a prerequisite from a procedural aspect for that to happen. So how many have seen a copy of a promissory note that says paid to the order of, and it's in blank, and then there's paid to the order of, and it identifies a particular party. If it identifies a particular party and it's not in default, and essentially that party that acquires it from the negotiation, they call that negotiation. So an endorsement is considered a negotiation, a part of negotiation to how that particular document is transferred. So if it's payable to the order of an identified party, the pay on it has not, asserted any defense, or if there's anything wrong with the documentation itself. If it's bearer paper is paid, that means it doesn't identify the party, then the person that acquires that through transfer or negotiation becomes a holder. Okay, so right here, right? I can give it to Troy. I can say, hold that for me. But Troy can't do anything with this until I give Troy the go ahead. I say, you know what? Someone wants it? Yeah, go ahead and sell it for $50. Once he gets the instruction from me, and I could prove, and he could prove that he got instruction from me, or I can come in and say, yeah, I gave him authority to do that. He can't do nothing with that phone. 9 times out of 10, that's what you're dealing with. You're dealing with a holder that doesn't have instruction or any proof that the person they acquired it, if they even acquired it from that person, allowed them to go forward and try to collect on it. That's a problem. Holder in due course would mean Troy bought this from me. There's nothing defective with it. There's nothing wrong with it. We checked it out. He came in. Everything's working. He tested it out. It's his now. And he can go and do whatever he wants with it. See the difference?
Yeah.
Does that make sense?
But
Can
he collect from you?
Yeah, well, he can do whatever. He can do, at this time, it's his. If he's the second, for the first the second definition. I'm talking about trying to give you the idea between holder and due course. And its relation to bearer of an identified party, a bearer instrument, or payable to the order of identified party. I know it's kind of confusing, but so all right. So if I own this, right, and I draft up, there's a note that I had that I filled out when I purchased this, and I have a receipt for that, and I paid to the order of Troy, right? There's nothing wrong with this right here, right? It's in good shape. It's cool. Nothing wrong with it. Troy checks it out. It's working. Cool. It's your, all right, everything's good. It's his now. He can do whatever he wants with it at that point in time. If it's not in default and there's no defection with it. All right? It's a good faith purchase. He paid value for it and he has proof. As I say at the time, it's $100. I don't know. He paid me $100. Nothing wrong with it. Cool. I'll stamp it over to him, pay to the order of Troy Smokes. It's his. Now, on the other hand, if I say, hold on to this for me, shop it around, see, whatever. I'm gonna say pay to the order of in blank, not specifically to him though. So the first one is paid to the order of Troy Smokes. The next one is just paid to the order of in blank. Hold on to this, shop it around, see, if you can sell it. If you can sell it, then come back to me, and I'll see if that's something that I want to do. He don't have authority to do to sell this without my authorization. Does that make sense? Alright, so now, and that's what's typically what you're dealing with. So you gotta look at your documentation. And if someone provides some documentation to you in the form of a note, you need to look at that note. Alright, cool, this is bearer paper. Or this is specially endorsed, paid to the order of an identified. Okay.
So just to be clear, what I heard you say is that if you sign a receipt selling it to me, I'm now the holder in due course.
Correct.
Because
Well,
you
that's
sold
an element.
it to
That's
me.
an element. So it is a little bit confusing. So relative to this,
Yes.
you could be paid to the order of, specially endorsed,
Mm-hmm.
or paid to the order of and blank. Okay.
Okay.
The receipt is just something additionally that you would have to show to show that you suffered an injury.
Mm-hmm.
Does that make sense?
Yes.
All right. Cool. So we're really just dealing with paid to the order of specially and then blank. The receipt is extra, so that's just what you would have to prove if you try to go to another level with it.
Mhm.
And say, wait, no, I bought this, I purchased this, I got value for this, here's my receipt, I suffered an injury,
Mhm.
I'm here to collect. And someone beats you, they take the phone. Does that make sense? Does that clarify? And as I said here, when made payable to the order of an identified person, it's referred to as order paper. Sometimes order paper is called specially endorsed, so it'd be specially endorsed. 9 times out of 10, it might be endorsed, but the party that is specially endorsed to is not the party that's bringing the action against you. Okay? And the reason for that is because now, I'm sure that we're all aware, most of these encumbrances are purchased in the secondary market. It happens off right away. And the reason why that happens is because it allows more money for the alleged lender, who's really not lending you anything, to get more obligations and sell them. And that's why they set up the whole operation, in the secondary market with the government. A lot of times the government is purchasing these obligations right off the bat. As soon as you execute it with it, they have programs in place where, they have the investors already. They have the investors waiting to buy these collateralized debts, but they need the people. And they get you to come in, house, 3.5%, credit card, 0 interest for whatever. But they can't function without you. They need you to come in, and they say, all right, cool. 1, 2, 3, 4 got credit scores of 800. These 5 got credit scores of 600. And these ones, I don't know. So, we promise you this. If you buy these set of loans, we're going to guarantee you this amount of, not guarantee you this amount of return, but we're going to give you credit enhancements for purchasing this. You're going to get paid out first. And in the event that people default, the people that purchase the ones under here are going to take the hit first. But you're guaranteed this. Alright? So they're like, alright, cool. That makes sense. And then it's less risk for the person that's originating the debt because they ain't putting up anything. They just getting the people. Suffer no injury, single paper. Fair debt. So I'm gonna go right into, and this is the main subject matter that I want to go. Now, I want to get out of the technical stuff because as a consumer, it really doesn't pertain to you. I mean, if you get to the point where you're arguing things like that, that's a problem. That's a problem. You don't want to engage in any subject matter. The only thing you need to know is if this is debt, which I'm gonna explain it is. Are you a consumer? Is that a creditor, or is that a debt collector? That's it. That's as far as your knowledge needs to go. Anything else that you try to engage in or figure out, you shouldn't be doing it. You're just making a headache for yourself. Because you could deal with them based off of this. That's it. Now, if you have a true creditor before you, which don't think there really is anymore, honestly, especially with, how the whole society's been going, you gotta take another tactic. You gotta be a little bit more intricate. And there's things that we have in place. I'm not gonna really discuss all that right now, but there's things that we have in place where you can look for certain things that they have to disclose to you in the original agreement. And there's things like disclosure or misrepresentation, things that you can go into with the origination of the document that you can use against them with the truth in lending and some various other laws. But what I want to deal with particularly is this, because this is what you're going to do. We're right into it. So the Fair Debt Collection Practice Act, everybody's familiar with that, right? FDCPA, I would probably say. Okay. is to eliminate debt collection practices by debt collectors to ensure that debt collectors who refrain from using abusive practices are not competitively disadvantaged and to promote consistent state action to protect consumers against debt collection abuses. Okay? Debt collectors and possibly creditors. So a creditor too, someone that allegedly originated your debt, can be subject to it. All right, so this is important. What you have to understand when you look at anything, any obligation that you have, what you have to understand is under the act or the definitions. This is so important. It might seem simple, but it's so important because this can tell you exactly what you're looking for, how to deal with, and when you go and how you move forward with anything. So the first term under the FDCPA is communication, 1692-82. The term communication means the conveying of information regarding a debt directly, indirectly to any person through any medium. So that's pretty broad, right? So I don't care if it doesn't make a demand for, if it makes a demand for payment. So say for example, your house, you know, you got foreclosed upon, they have a judgment against you, you get a notice of sale. Even though that notice of sale is not requesting a monetary amount, that is still a communication in connection with collecting the debt. So anything that's in that document needs to be on the up and up. It better be no confusion, no misleading, nothing. And the parties that are identified in that document need to appropriately identify who they are. I don't want to see mortgage company is. If you tell me this is the mortgage company, I'm suing you. Why? Because you're not telling me if you're a creditor or a debt collector. That's it. Any misrepresentation. As a least sophisticated consumer, I don't know if mortgage company, I don't know what that means at this point in time. So you almost want to be ignorant in a sense. I sent them this. They said it was the mortgage company. I don't know who the hell the mortgage company is. I want to know if I'm dealing with a debt collector or a creditor. That's it. Turn around and sue them. Consumer is you. Any natural person obligated or allegedly obligated to pay a debt. All right? Creditor. All right, this is important. Any person who offers or extends credit, creating a debt, or to whom a debt is owed. But listen to this. But such term does not include any person to the extent that he receives an assignment or transfer of a debt in default solely for the purpose of facilitating collection of such debt for another. So that's the transitional document in every mortgage case. Every one. I've yet to see one where there's not an assignment. Because they sold it. What happens a lot of times, they sell it behind the scenes. They don't let you know, which they do have to let you know if you look at your paperwork. They don't have to give you prior notice, but they got to give you notice. So someone owns it, but the person that originated it might be retained servicing rights, whatever the case may be. But the minute you see assignment, transfer, sale, it should be a light bulb going off in your head. Oh yeah, I got one. That should be the attitude. I got one. Debt. This is important too, because not every single debt is covered, and I'm going to explain that. Because so some people that have investment properties, commercial properties, you might not have this afforded to you, and I'm going to explain why. It means any obligation or alleged obligation of a consumer to pay money arising out of a transaction in which money, property, insurance, or services which are the subject of the transaction are primarily for personal, family, and household purposes. So money, property, insurance, and services for personal, family, or household purposes. This is important. Now there's ways around it. It depends on how you did your paperwork. So say you do get an investment property. If you have a rider on there, then they can use that against you. So you're going to have to prove in some way that you obtained that property was permanent. So if you obtain something for a commercial gain that you're not, using, it's probably not going to fall under unless you're going to have to be able to prove some way. And I only bring that up just because I had a client. She has probably over 40 investment properties. And I tried it. I tried taking this avenue. All right, maybe I can somewhat. It didn't work. So you gotta stick to that. So that's huge. All right. Debt collector. Alright. So the term debt collector or the mill who regularly collects or attempts to collect directly or indirectly debts owed or due or asserted to be owed or due another. So that's kind of wordplay right there. Notwithstanding of the Exclusion Act, which we'll get into, of the last sentence of this paragraph, the process of collecting his own debts uses any name other than his own, which would indicate that a third party is collecting or attempting to collect such debts. That's huge. Why is that huge? Anybody? Anybody have any idea why is that huge? Why is that huge?
I know, like for instance, in my situation, I know that I received something from PennyMac. It says PennyMac, but then they'll come back and call themselves another name other than PennyMac, and so it gets confusing. It's like, well, who is collecting what?
Right. All right. So this is what they started doing. You can go down to the Department of State, pay $150, get a license for debt collection. You go right to the FDIC. Yeah, you go right to the FDIC of banks that went out of business, no longer functioning, and you can buy debt by the millions for cents on the dollar.
Really?
For cents on the dollar. I could create an entity right now. Khalifa Anatani Debt Collection. Go buy up all this debt. Got me a couple dollars, go buy some debt. It may be owed, it may not be owed. I don't know. Send out correspondences to everybody. Say I send it out to 100 people. 10 people gonna pay me.
Yep.
They gonna pay me. I guarantee it. Because we good-hearted people. Yeah, I did have that. I didn't have the money then, I got the money now. Let me see if I can make a payment plan. That person that bought that debt, they have no way to authenticate that you owe anything. And this is what they started doing. That's how the whole housing thing, that's what they started doing. You got people creating all these sub-corporations, LLCs, all these new servicing companies coming out of nowhere. Green Tree Lending Services, Portfolio Recovery Services, Nation Star Mortgage LLC, don't even answer. You know, on your accounts. In your bank account now. So that's what white folks do. Every day. It's crazy. So that's why that's important, though. That's why that's important. If you did not execute a contract with that person, that is someone trying to collect in a different name. Prime example. Who has a student loan in here? Now there's exceptions, so I want to be clear. A private student loan. Sallie Mae. Now, Sallie Mae Inc. Well, let me explain this. Anybody has a Sallie Mae? Sallie Mae is tricky as I don't know what. Alright? This is why. They got SLM Corporation, which is Sallie Mae, right? They got Sallie Mae Bank. Okay? They got Sallie Mae Inc., which is now Navient Solutions Inc. Okay? Navient Solutions Inc. is no longer a part of Sallie Mae. They have a contract that governs their relationship, but they're no longer a part. 9 times out of 10, your original obligation on the promissory note says Sallie Mae.
Right now it says Navient.
I'm gonna get to that. Now, guess who's the lender though on your note? Sallie Mae Bank.
Sallie Mae Bank, okay.
Under AMS, which is a subsidiary of Sallie Mae Bank. Who's collecting from you though? Navient Solutions Inc. If you send them a notice of dispute, who's the current creditor? Guess what they're gonna say? Navient Solutions Inc. Formerly known as Sallie Mae Inc. What's the problem with that?
Third party you were talking about.
Exactly. Even though they're under the same corporate control, it's a separate entity that was created for the sole purpose of collecting a debt. I got people with $50,000, $60,000 student loans. But they don't know what to do. Because It's trickery. You see what I'm saying? We create all these sub corporations. You send out a couple of notices. You don't know what you're dealing with. But they send you a copy of your promissory note, right?
Mhm.
When you dispute it, who does that promissory note identify as a lender? Sally Mae Bank. I asked for the creditor who is owed. We're your creditor. How you my creditor? The note says Sally Mae Bank. Y'all got the same EIN? Nah. Then y'all not the same entity. What is that?
EIN, that's the,
It's just a number to identify,
Right.
you know, the business
Right.
in relation to the IRS,
Right.
you know, for make the payment. But see, that's the trickery, though. You're thinking, oh, they're all one and the same. Nah. There has to be some, you have to be able to certify where you play in that part. If you're the servicer and you're authorized to collect by them, say that. But this is where the misrepresentation comes in. But we don't know. We just know that we did sign the note. Because you don't know what happened to that original note. They sell them all the time. 9 times out of 10, it's in some Remick trust. Residential mortgage investment conduit, which is just a static entity. It's a entity that they create for the sole purpose to act as the holder of the assets. And then they assign a trustee that allocates, you know, the payments of the assets that go to the trust to an investor. And I'll get into that. But long story short, they're not the owner. But they confuse you, you know, to think as such. Back to the definition. Any creditor who, in the process of collecting his own debts, uses the name other than his own, which would indicate that a third party is collecting or attempting to collect the debt. But you don't get that with any bank. You know, if you got Wells Fargo Bank NA collecting from you, they'll have Wells Fargo Home Mortgage Inc. So they create entities for the sole purpose of collection. So if they're sending you any correspondence, and I'm gonna get into the law, and the FDCPA is 14 pages. That's it, 14 pages. If there's any provision of that act that they don't, you know, institute or they deviate away from, you should be taking them right into court. I don't care if it's federal court or if it's small claims court. Small claims is like the Wild Wild West. Anybody can go up in there. And you go before a judge and you say, hey, this is what happened and this is this. You don't have no knowledge. I go into small claims court for people all the time. And it's crazy because in there it's like 50 people in there. No one has an attorney. There's 3 attorneys in there and they're just calling people in. Let's make a deal. Set up a payment plan. Let's make a deal. It's like a bank. It's like a bank. I'm like, yo, this is crazy. It's crazy. Alright. So for the purpose of this section, 1692F6 of this title, such term also includes any person who uses any instrumentality of interstate commerce or the mails in any business. The principal purpose of which is the enforcement of a security interest. What does that mean? If somebody has some type of interest in your collateral. And this is more particular to foreclosure. They'll say it's an in rem act, just coming after the thing. We're not collecting a debt. You know they're a debt collector. They can't. Why? Because if a debt collector has it, should any interest be accruing?
No, not at all.
If they charge you interest, that's a problem. The interest accrues from day to day at $5.57 per diem. What? The exceptions of a debt collector, you gotta be really. Comes in for a private company, he's not acting in the capacity, in that official capacity. Does that make sense? So you got to be careful with that. Now there's an exception when you're dealing with students. They're federal, okay? So you got to be careful with that. There's still a way around it. It's just that this particular law wouldn't be used around. So a guarantee agency, and I can tell you right now, FEA is a guarantee agency. Pennsylvania agency. Send you your